Hello. Hello, good evening, everyone. Today is day 11 of our series Daily Drill for Breaking Prelims UPSC 2026. And today is the last day of polity, which was the part of our questionnaire. But students had requested that they wanted us to discuss the articles of constitution in such a way that you can remember it. So we'll conduct one session after the 100-day series gets finished. Post that, we'll conduct special sessions in which we can help you remember the articles in a very specific manner, in a very clear and interesting manner also, right? So today is last day of polity, and it will have questions from anti-defection. I announced it on the in the session of Saturday, which was of Friday, that will have topics from National Commission for Review or Working of the Constitution, anti-defection, and all these topics which were left from Laxmikant. These topics, from these topics, the question will be made. Okay, so let's start today's discussion. And these questions are simple but conceptual. You can still make them wrong if you don't remember the concepts really well. Okay, so let me just share today's solution PDF with you. While I'm sharing the PDF, let me tell you, for people who are new to our channel, that this is a free mini prelims test series that we're providing to our students, in which question paper is released at morning 9:30 a.m. And you can solve those 25 questions in 30 minutes, and evening 7 p.m. we discuss those questions, not just from knowledge point of view, but also from application point of view. For example, of course, you will have to read things, but once you have read things, how to apply those things in a very smart manner. Okay, so let's start with the first question. Yeah, so the first question, if you all can read, question number 1, the Election Commission of India has the power to resolve disputes related to, okay, so split and merger of recognized political parties. So split and merger of recognized political parties is one of the work, and the other is recognition of political parties and allotment of election symbols. There's a specific act which gives election commission power to decide on the allotment of election symbols. Disqualification of elected members under anti-defection law comes under speaker or chairman of that legislative assembly. Okay? Delimitation of constituencies is also under delimitation commission. Okay, so the answer will be option B. Okay, recognition of political parties and allotment of election symbols. Yeah. And in this, ECI has exclusive authority. Okay, ECI has exclusive authority under election symbols reservation and allotment under 1968. Try and remember this act. I'll repeat: election. It's not order act, but it's an order of election commission, election symbols reservation and allotment order 1968 guides election commission and gives executive authority and exclusive authority to ECI to recognize political parties, allot symbols, including resolving disputes arising from splits and mergers. Split and merger is just one part of recognition of political parties and allotment of election symbols. Okay, let's move to the next question. Election Commission of India. The second question is also on Election Commission of India. Election Commission of India is mentioned under Article 324 and 342 have written, it's 324, and it is mentioned in part 15 of the Constitution. Always remember. Okay, part 15 is election. So election commission consists of CEC and 2 election commissioner. Yes, it has 3 members, 1 CEC and plus 2 ECs. The Union Home Ministry decides the election schedule for both general elections and by-elections. Wrong. Election Commission of India decides when will be the schedule for election and by-elections. So Home Ministry does not have power to decide on this. Okay. The Chief Election Commissioner and election commissioners have equal decision-making powers in all matters. So why will, if they are going to have equal decision-making powers, so why will one will be called chief and others will be called election commissioner. No, at some points when there is a casting vote is required, when there is a tie-in decision, then chief election commission's point of view will be the main point of view, will be the deciding point of view. So this point is also wrong. They do not have equal decision making power. CEC has more power than election commissioner, right? So the answer will be, which of them are correct? A, one only. Okay, so statement 1, ECI currently has CEC plus 2 ECs. ECI independently decides election schedules. Home Ministry has no role in it. Okay, and CEC has casting vote in case of disagreement. If there is a disagreement amongst the 3 election commissioners, CEC will be the deciding authority. Okay, let's move to the next question. The value of vote of each MLA in the presidential election is determined by population of the state divided by number of elected MLAs? No. So this is how it looks, okay? Population of state divided by number of number of seats of MLAs or number of elected MLAs. Number of elected MLAs divided by 1000, that is divided by 1000, which becomes into 1 upon 1000. This mathematics is clear to you? Okay, so now next, see, now option B and option D both are having the same formulas. Population of state divided by number of elected MLAs, then divided by 1000. But which population? Which population? 1971 data or 2011 data? So 2011 data has not been taken in much of the things. So it is 1971 data only. So the answer is option B. Population of the state, from 1971 census divided by number of elected MLAs, which is then divided by 1000. Very simple. And this is given. This process of election is mentioned in which article? Tell me, which article? Article 55 is mentioned in Article 55. Keep remembering along with me whatever we are studying. Okay, so Article 55 specifies the formula. Okay, let's do the next question. Question number 4, consider the following statement regarding the presidential election in India. If the election is declared void by Supreme Court, all acts done by president before the judgment become invalid. So this is not true. For example, if the elections is not found in the right manner, even then whatever decisions president has taken because before that happened will be considered valid, in the manner that it was done in the fairest point of view. Okay, so this is wrong. It will not be declared void. If the election is declared void, all acts done by president before the judgment does not become invalid. It stays valid. Election can be postponed. 1 second. Yeah, question number 4. Statement 2. The first statement we have made wrong because it does not become invalid. Election can be postponed if some legislative assemblies have been dissolved and elections are pending. No, the presidential election cannot be postponed. It has to be done. Presidential position cannot be kept vacant. Can't be postponed. Okay, it can't be vacant before the expire of 5-year term. This election has to be done even if some assemblies are dissolved. We will not wait for them. The Constitution prescribes specific time limits within which president must declare assent to bills. No, there is no specific time limit. That's why president has power of pocket veto because nothing is written about the time. That's why third statement is also wrong. Fourth statement, nominated members of parliament are eligible to vote in presidential elections. No, only the elected members of both parliament and state legislative assembly, okay, are eligible. Okay, this is written in the first page of Laxmikant of President chapter. It is also written in all the articles from 52 till 71, 72, which are the articles related to President of India in our Constitution of India in part 5. So which of the above are correct? None of the above are correct. You can read the conclusion. You can read the solution. You can also download the solution from the comments and description given, right? So all the things were wrong. Only elected members form electoral college, not nominated. Elections cannot be postponed. Presidential election can never be postponed. People who are reading for the first time, okay, for them this might be new information. For nomination to the Lok Sabha, for being able to fight elections for Lok Sabha, a candidate must be resident of the constituency. Residency is not enough. For example, somebody from UAE or Dubai or America comes and stays in some district of any random Maharashtra. So that doesn't make him, that doesn't allow him to participate in the elections. Okay, any citizen of India whose name appears in the electoral roll of any constituency. So citizen is important, and they should be mentioned. They should be appearing in the electoral roll of India. They should be eligible to vote in this country, not just citizens. So if they can vote in the country, they can get, they can fight for election also. So the option is B. Let's move to the next question. Section 4 of RPA, Representation of People Act 1951, requires, this is not written in Constitution, it is written in RPA 1951, Representation of People Act 1950-51 is part of our GS paper 2, very important. So requires a person to be citizen of India and have the name on the electoral roll also. Both things are required. Okay. Next question, number 6. Consider the following regarding contesting election from multiple constituencies. In India, there is no law restricting candidates from contesting in one Lok Sabha election from 3 constituencies. So 3 constituencies is not wrong. The maximum is 2 constituencies. Maximum 2 constituencies. Okay, you might be knowing Rajiv Gandhi, Rai Bareli, and Wayanad. Narendra Modi also fights from 2 constituencies. If candidate wins from multiple constituencies, their party must bear the cost. No, party doesn't bear the cost. Candidate himself or herself, why just we are talking about men, candidate himself, herself have to bear the cost of the constituencies, the by-election to the constituencies which got vacated. So the answer will be neither 1 nor 2. Both statements are incorrect. Okay, RPA 1951 amended 1996 restricts candidate to maximum 2 constituencies. So earlier it was not so, and after 1996 amendment to RPA 1951 has restricted candidate to 2 constituencies in Lok Sabha. Please remember these facts. Okay, so current rules also don't demand candidates' party to bear the cost of by elections, but instead candidates themselves have to pay for it. Consider the following statement regarding state ministers' eligibility. A person who is eligible to vote can be made a minister in a state for more than 6 months if they are not a member of state legislature. It can only be done till 6 months, and before 6 months, they have to be member of either of the state legislative assembly or legislative council. Okay, before 6 months they have to join any of the legislature. Okay, any of the legislature. So this is wrong. For more than 6 months they cannot be made a minister. According to the Constitution, a person convicted of a criminal offense and sentenced to imprisonment for 5 years is permanently disqualified. So there is no permanent disqualification from becoming a minister. It's only 6 years suspension. It's not permanent disqualification. If they are convicted for 6 years, they'll not be able to fight in the election, but post that they can. Okay, so both the option are wrong, and which of them are correct? Neither 1 nor 2. Okay, both statements are incorrect. Person must be a member of state legislature or become one within 6 months. Article 164 clause 4 RPA 1951 provides 6-year disqualification, not permanent. Let's go to question number 8. In elections of Lok Sabha or state assembly to be declared elected, the winning candidate must have 50% of votes, get more than any other candidate, simple plurality, at least 33%, win by a margin of at least 1,000 votes. So if you have read our Constitution of India, Indian Constitution, our Constitution at Work, Indian Constitution at Work, class 11th NCERT, it has very clearly mentioned in the chapter election the difference between proportional representation kind of voting system and first past the post system, which is what India follows. First past the post system, where a lot of members can fight from one constituency, a lot of candidates, and whoever is getting the highest vote, even by the margin of one, will win that constituency, will win that seat for that constituency, even if they are winning by 1 vote or 2 votes, right? So the answer is get more votes than any other candidate. Okay, if 5 are fighting, even if the one is getting 25%, others are getting lesser than that, so that person will be the winner. Okay, so first past the post system. Please read about it. Question number 9. What is the basic structure doctrine? Basic structure doctrine given by Supreme Court in Keshavananda Bharati case, Supreme Court. Okay, I hope all of you have it by heart. The Constitution of India explicitly defines its basic structure in terms of federalism, secularism, fundamental rights, and democracy. Wrong. Constitution of India never talked or even mentioned about basic structure. It has been evolved through judicial review system of Supreme Court. Supreme Court has given it this term that legislature, parliament can amend the constitution but will not change the basic structure of the constitution. They can. This happened in Keshavananda Bharati case. Okay, the Constitution of India provides for judicial review to safeguard citizens' liberties and preserve the ideals on which the constitution is based. That is true. Judicial review is there in several articles, 32 to 26. So this is right. Which of them are correct? B, 2 only. Okay, article 13, 32 also. Okay, 13 also. Let's move to the next question. Judicial review in India implies, what does judicial review? The power of judiciary to review all legislative enactments before they're assented to by the president? No. All legislative enactments can't be checked by judiciary, and that's not how judicial review works. Okay. The power of judiciary to question the wisdom of laws. That's not their job to question the wisdom of laws. They may question. That depends on them, but it's not they have to question all the wisdom of laws. The power of judiciary to pronounce upon the constitutionality of laws and executive orders. Yes, this judiciary can do. If there is any law and executive order being passed, they may check whether this thing is constitutional or not. If it is unconstitutional, if it is against the basic principles of the constitution, it can become void, null and void. Okay, so the judicial review means See, this question, everybody knows what judicial review, but you can get confused among these 4 options. Okay, so you should know the core, the juice of the meaning of judicial review, right? So it's checking the constitutionality. But does judiciary check all the laws? No, it doesn't. Okay, judiciary to review its own judgment? No, it's not about reviewing its own judgment. This is another power. Okay, that is called appellate jurisdiction, review jurisdiction, to review their own judgment. That is also judicial review means judiciary power to examine laws or executive order, whether conforming to constitutional provisions or not. Question number 11. The Supreme Court of India struck down the 99th Amendment to the Constitution of India as being violative of 99th Amendment Act, brought National Judicial Appointment Commission, NJAC. Okay, so NJAC was brought by 99th Amendment Act, which was made null and void by judiciary. Why? Because they thought independence of judiciary is basic structure, one of the basic structure of constitution, and making executive powerful in deciding who will be the judge, who won't be the judge, selecting judges will compromise the independence of judiciary. Okay, in this, what was happening? A commission was being made where there would be some members from executive and also some members from judiciary, which would be different from the currently working collegiate system, where only judiciary judges are being powerful to decide who will be the next judge. Okay, so based on that, they did not want executive control over it, and they made it null and void. So independence of judiciary was the main reason, not the separation of power. Though independence of judiciary is part of separation power, the main reason given was independence of judiciary in the Advocates on Records Association versus Union of India case 2015. This was the name of the case. Advocates on Record Association versus Union of India 2015. That was the name of the case. Let's move to question number 12. The Constitution of India has evolved through judicial interpretation to address contemporary challenges while maintaining its basic framework. Yes, that much of possibility and flexibility Constitution of India provides, but it is being evolved with time, especially Article 21, right? Recently, right to internet has been given through Anuradha Bhasin case. Before that, right to privacy was given, right to environment has been given, right to food has been given in the PUCL versus Union of India case. So right to environment through MC Mehta versus Union of India cases. So through judicial interpretations, the Constitution of India is evolving, and Supreme Court's power of constitutional interpretation allows it to read new rights and principles. Okay, so that's why, yes, because Supreme Court has been given the power of constitutional interpretation, they keep reading new rights and principles through which Constitution of India is evolving. So statement 1 is also right, statement 2 is also right, and statement 2 is giving reason behind why the Constitution of India is evolving. Okay, so the option will be A. Both are correct, and statement 2 is also giving an explanation. Let's move to question number 13. DPSP cannot override fundamental rights, but both should be harmoniously interpreted. But both should be harmoniously interpreted to achieve constitutional goals. This was the main, one of the main, lines that was discussed in Kesavananda Bharati case, under which basic structure doctrine was brought. This was also talked about. Actually, Kesavananda Bharati case was evolved because of this, because there was fight going on between DPSP versus fundamental rights from independence onwards. So, government to implement the welfare through DPSP, whenever they were bringing some laws were being conflicted with fundamental rights, which citizens were bringing into the court, right? So sometimes courts was in favor, sometimes courts was not in favor of executive, like Shankari Prasad case and Golaknath case. So through that fights and conflicts, Kesavananda was evolved that parliament can abridge a little bit of fundamental rights, but that should not change the basic structure doctrine. Okay, so this is right. The 42nd Amendment Act attempted to give supremacy. Yes, 42nd Amendment, called the mini constitution, brought by Indira Gandhi. She was trying to give supremacy to DPSP over fundamental rights, but it was moderated by subsequent judicial interpretation in Minerva Mill case. ओके तो केशवानंदा भारती के बाद 42nd अमेंडमेंट आया और उसमें वो उस चीज को ठीक करना चाह रही थी. इंदिरा गांधी पार्लियामेंट का पावर बढ़ाना चाह रही थी कि नोबडी कैन कम इन फ्रंट ऑफ अस, बट मिनर्वा मिल केस से वापस जुडिशियल रिव्यू को पावर देते हुए उन्होंने उस चीज को supremacy को हटा दिया. There is no supremacy, there's harmony between DPSP and fundamental right. So both statement 1 and 2 are correct, and statement 2 is the correct explanation for statement 1. Let's go to the next question. With reference to article 142 of the constitution. अब 142 बोलते ही मेरे दिमाग में आ जाता है complete justice का जो पावर सुप्रीम कोर्ट को दिया हुआ है. ये क्वेश्चन मेंस में भी आ चुका है, which I myself have also written in I think 2018 मेंस में भी आ चुका है. With reference to article 142 of Constitution of India, which of the following statement is correct? अगर आपको article 142 का मतलब पता है, आप आसानी से यहाँ पहुंच जाओगे. Prohibition or limitation contained in ordinary laws cannot act as prohibition on constitutional powers under article 142. 142 में सुप्रीम कोर्ट को पूरे पावर्स मिले हैं कि कंप्लीट जस्टिस लाने के लिए आप आपके सब जो नेचुरल जस्टिस, जो बेस्ट जस्टिस है, तो कोई चीज आपके बीच में नहीं आएगी टू अराइव ऑन दैट कंप्लीट जस्टिस. सो ऑर्डिनरी लॉज में कोई छोटे मोटे एक्ट प्रोहिबिशंस दिया तो वो बीच में नहीं आएगा. तो दिस इज द राइट आंसर ए. सुप्रीम कोर्ट कैन एक्सरसाइज व्हेन स्पेसिफिकली प्रोवाइडेड बाय स्टैट्यूटरी लॉ? नो. Article 142 powers are limited to matters where Supreme Court has original jurisdiction. नहीं, original jurisdiction 142 में नहीं आता है. ठीक है, go and see original jurisdiction of Supreme Court कौन से article में, बताइए मुझे in the comments. The Supreme Court requires Parliament's approval बिफोर एक्सरसाइजिंग पावर अंडर आर्टिकल 142. नो, किसी के अप्रूवल की जरूरत नहीं है सुप्रीम कोर्ट को आर्टिकल 142 में जजमेंट लेने के लिए. ठीक है, लेट्स मूव द नेक्स्ट. द डॉक्ट्रिन ऑफ कलरेबल लेजिस्लेशन इज यूज्ड टू डिटरमाइन वेदर. अब क्या होता है डॉक्ट्रिन ऑफ कलरेबल लेजिस्लेशन? ये होता है कि जब पार्लियामेंट कुछ काम कर रही है, लेजिस्लेचर, तो लग तो रहा है कि वो कॉन्स्टिट्यूशन के विद इन काम कर रही है, बट समहाउ इट इज ट्राइंग टू बाईपास एंड ट्रांसग्रेस इट. है ना, लग रहा है कि ये कॉन्स्टिट्यूशनली वैलिड है, बट अगर ढंग से देखा जाए तो इट इज नॉट. सो ट्राइंग टू कलर इट कि हाँ दिख तो सही रहा है, बट एक्चुअली साइड से नहीं है. दैट इज व्हाट इज डॉक्ट्रिन ऑफ कलरेबल लेजिस्लेशन. लेजिस्लेचर हैज एक्टेड within its constitutional competence while apparently transgressing it. ओके, फंडामेंटल राइट वगैरह से वायलेट करने वाले चीज को कलरेबल लेजिस्लेशन नहीं बोलते हैं. इसका आंसर है ए. ठीक है, वेदर लेजिस्लेशन हैज इनडायरेक्टली, तो जो चीज वो डायरेक्टली नहीं कर सकते, घुमा फिरा के करने की पावर. Okay, which one of the following schedules of Constitution of India contain provisions regarding anti-defection? Very important law. Anti-defection क्यों लाया गया था? बिकॉज बहुत ज्यादा अनस्टेबिलिटी हो गई थी गवर्नमेंट में. बहुत फेमस फ्रेज है आया राम गया राम. तो जब पार्लियामेंट में लोग इलेक्ट होकर आते हैं, एक पार्टी मिलकर गवर्नमेंट बनाती, कई बार एक पार्टी के पास मेजोरिटी नहीं होती, 2-3 पार्टीज मिलकर बनाती है, और कई बार उस समय क्योंकि एंटी डिफेक्शन नहीं था, तो मान लो एक पार्टी के पास मेजोरिटी है और वो बन गई, पर कोई और पार्टी ने उसकी एमपी को खरीद लिया या उसको अपने साइड रख लिया, जैसे भी पैसे या जो भी देकर, तो उससे क्या हो रहा है, उसका पावर फिर कम हो जा रहा है और फिर बार बार गवर्नमेंट टूट जा रही है, जिसके कारण फिर से इलेक्शन होगा और बहुत सारा खर्चा आएगा. तो इस तरह का जो इनस्टेबिलिटी विच इज ऑल्सो कॉल्ड हॉर्स ट्रेडिंग इन द पार्लियामेंट इज नॉट करेक्ट. उसके लिए एंटी डिफेक्शन आया था 52nd अमेंडमेंट से, जिससे 10th शेड्यूल लाया गया था. ये ध्यान रखिएगा. ठीक है, सेकेंड शेड्यूल इज अबाउट व्हाट? सैलरीज एंड अलाउंसेस. ठीक है, फिफ्थ शेड्यूल इज अबाउट शेड्यूल ट्राइब एरियाज. ये सैलरीज एंड अलाउंसेस. 8th शेड्यूल इज लैंग्वेज. 22 लैंग्वेजेस हैं इसमें, एंड 10th शेड्यूल इज द आंसर. ठीक है, 52nd अमेंडमेंट एक्ट 1985. Consider the following statement regarding anti-defection law and speaker's authority. The decision of speaker chairman regarding disqualification under anti-defection law is subject to judicial review. Yes, it is subject to judicial review. अगर एक बार स्पीकर ने डिसीजन ले लिया तो जुडिशियल रिव्यू हो सकता है उस पे. The speaker chairman can decide on disqualification cases even when they themselves are facing a motion of no confidence. सो ये गलत है. अगर उनके अगेंस्ट ही नो कॉन्फिडेंस चल रहा है स्पीकर और चेयरमैन के, तो उनका खुद का कॉन्फिडेंस नहीं है, तो फिर वो डिस्क्वालिफिकेशन केस पे नहीं बैठ सकते, क्योंकि वो कॉन्फ्लिक्ट का सिचुएशन हो जाएगा. तो ये गलत है और ये सही है. तो स्पीकर और चेयरमैन को पावर दिया गया था एंटी डिफेक्शन में कि पार्लियामेंट में जब कुछ ऐसा हो रहा है, स्पीकर हैज टू डिसाइड कि जो जिस इंसान ने पार्टी छोड़ी है, जिस तरीके से छोड़ी है, वो सही है या गलत है. ठीक है, बट it has been subjected to judicial review through Quixote Holoan case. ठीक है, तो उसमें बोला गया था कोई भी एक्ट जिसमें किसी भी प्रकार का जजमेंट हो रहा है, क्वासी जुडिशियल पावर्स अगर किसी को मिल रहे हैं, तो वो सुप्रीम कोर्ट के अंदर आएंगे ही, चाहे वो पार्लियामेंट्री बॉडी के थ्रू किया जाए या एग्जीक्यूटिव बॉडी के थ्रू किया जाए. तो एनी ट्रिब्यूनल के भी एनी ट्रिब्यूनल्स डिसीजन, स्पीकर्स डिसीजन अल्टीमेटली can be taken back to Supreme Court, right? So Quixote Holoan case था. तो first is right, second is wrong. Okay, so option will be A. Quixote Holoan case 1992 का है कि speaker's decision is subject to judicial review, और speaker cannot decide disqualification matter जब उसके against no confidence है due to conflict of interest. Question number 18. Consider the following statement regarding party merger and split provisions under anti-defection law. 1/3 of the members of political party can split from the party without attracting disqualification. ये पहला वाला जो 52nd अमेंडमेंट से था ना, उस समय ये था, बट 93rd अमेंडमेंट से जो आया, 93rd ही था ना, 91st, आई थिंक 91st था, हाँ 91st अमेंडमेंट एक्ट से जब दोबारा इसको हटा दिया गया, 91st अमेंडमेंट एक्ट से 2003 से, इस वाली चीज को रिमूव कर दिया गया था। ठीक है, तो क्वेश्चन, तो स्टेटमेंट 1 इसलिए गलत हो जाता है क्योंकि वो अब रिमूव्ड है, इट्स नॉट। अगर कोई 1/3 मेंबर्स लेकर स्प्लिट कर रहा है तो वो डिफेक्शन कहलाएगा। If a political party merges with another party, members are not disqualified under anti-defection law. हाँ, merger allowed है, 2/3 वो भी है ना। The anti-defection law recognizes voluntarily giving up of membership of a political party as ground for डिस्क्वालिफिकेशन। हाँ, अगर आप किसी पार्टी के मेंबर हो, उसके थ्रू आपको सीट्स मिले हैं असेंबली में, और अगर आप उसको यूं ही छोड़ रहे हो तो आप डिस्क्वालीफाई हो गए, दैट इज अ ग्राउंड फॉर डिस्क्वालिफिकेशन। तो ये भी सही है और ये भी सही है, तो आंसर विल बी 2 and 3। एंटी डिफेक्शन डिटेल में आपको आना चाहिए। ठीक है, तो मर्जर विद अनदर पार्टी, तो 2 and 3 सही है, 1 गलत है। 97 फर्स्ट अमेंडमेंट एक्ट, इससे पहले 52nd अमेंडमेंट एक्ट था, और उसके बाद 91st अमेंडमेंट एक्ट आया। प्लीज इसको याद रखना, एंटी डिफेक्शन में 2 बार अमेंडमेंट्स हुए हैं। अंडर द एंटी डिफेक्शन लॉ अंडर द एंटी डिफेक्शन लॉ अ नॉमिनेटेड मेंबर ऑफ लेजिस्लेचर कैन बी डिस्क्वालिफाइड इफ दे ज्वाइन एनी पॉलिटिकल पार्टी एट एनी टाइम आफ्टर नॉमिनेशन। नहीं, दे ज्वाइन अ पॉलिटिकल पार्टी आफ्टर 6 months। हाँ, जो नॉमिनेटेड मेंबर है, जैसे कि प्रेसिडेंट 12 लोगों को नॉमिनेट करते हैं राज्यसभा में, अब उनका मन किया किसी पार्टी को ज्वाइन करने का, तो 6 महीने तक वो ज्वाइन कर सकते हैं। 6 महीने तक जब तक वो ज्वाइन करेंगे, 6 महीने का टाइम उनको कॉन्स्टिट्यूशन दे रहा है कि आप आराम से ज्वाइन करो। पर अगर आप उसके बाद ज्वाइन कर रहे हो, देन दैट विल बी अ केस ऑफ एंटी डिफेक्शन। ओके, सो द नॉमिनेटेड मेंबर ऑफ लेजिस्लेचर कैन बी डिस्क्वालिफाइड अगर वो 6 months के बाद ज्वाइन कर रहे हैं। अगर वो पॉलिटिकल पार्टी कभी भी ज्वाइन एनी पार्टी एट एनी टाइम आफ्टर नॉमिनेशन, तो ऐसा नहीं होगा। 6 महीने तक सही है वो। दे वोट अगेंस्ट द पार्टी दैट नॉमिनेटेड देम, ऐसा कुछ भी नहीं है। दे एब्सटेन फ्रॉम वोटिंग ऑन एनी बिल, ऐसा भी नहीं। राइट, लेट्स मूव द क्वेश्चन नंबर 20। Consider the following statement regarding political party recognition in India. इसमें किसको पावर है? इलेक्शन कमीशन ऑफ इंडिया को। A political party must secure at least 6% of valid votes in 4 or more states in Lok Sabha to be recognized as a national party. This is true. ठीक है? The Election Commission of India has the authority to recognize political parties and allot election symbols. That is true. Both 1 and 2 are correct. Very simple question. One of the criteria for national party recognition is 6% votes. ECI has exclusive authority under Election Symbol Reservation and Allotment Order 1968. इसको याद कर लीजिए, Election Symbol Reservation and Allotment Order 1968. Election Commission of India reserve certain symbols. अब कुछ पार्टी के सिंबल्स रिजर्व्ड रहेंगे, जैसे कांग्रेस का हाथ हो गया या बीजेपी का लोटस हो गया, इट इज रिजर्व फॉर देम। तो कैसी पार्टीज के लिए रिजर्व कर सकती है इलेक्शन कमीशन ऑफ इंडिया? इट इज रिकॉग्नाइज्ड पॉलिटिकल पार्टीज, नेशनल भी स्टेट भी। ऐसा नहीं कि स्टेट पार्टीज का नहीं रिजर्व होगा, स्टेट पार्टीज भी अगर वो रिकॉग्नाइज्ड है तो। ठीक है, जैसे कि बीएसपी हो गया, है ना, जो तृणमूल कांग्रेस हो गया, जो रिकॉग्नाइज्ड है। Let's move the next question. Question number 22. Coalition government in India tend to be less stable than single party majority due to conflicting interest among alliance partners. ये बिल्कुल होता है। अटल बिहारी वाजपेयी का जो पहला गवर्नमेंट था इसलिए टूट गया था, क्योंकि 3-4 जब बहुत सारे पार्टीज मिलकर बनाते हैं और फिर उनकी कुछ चीजों में डिसएग्रीमेंट हो जाती है, वो अपना पावर दिखाते हैं, उनका अपना हाथ छीन कर, तो उस कारण से गवर्नमेंट पूरी की पूरी टूट जाती है। क्योंकि ये क्यों टूटती है? क्योंकि कंसेंसस चाहिए बहुत सारी पार्टीज में, और कई बार इस देश में डेमोक्रेसी में सबके अपने बहुत वेस्टेड इंटरेस्ट है, तो कई बार कंसेंसस नहीं हो पाता है, जिससे पॉलिसी पैरालिसिस हो जाती है, और गवर्नमेंट बार बार चेंज होना, बहुत ज्यादा चेंज होना किसी कंट्री के लिए बहुत अच्छा नहीं है। तो यस, स्टेटमेंट 1 इज ऑल्सो राइट, स्टेटमेंट 2 is also right, and statement 2 explains why coalition government is less stable. Okay, so option A. ठीक है, question number 23. Which of the following is not a requirement for inner party democracy? inner party democracy क्या होती है? कोई भी पार्टी है, चाहे कांग्रेस है या बीजेपी है, तो उनमें इनर पार्टी डेमोक्रेसी कैसे? मतलब इनर पार्टी डेमोक्रेसी मतलब उसमें हर लोगों को इक्वल चांस मिल रहा है ऊपर आने का। ये नहीं कि कोई किसी का बेटा है इस कारण से उसको पावर मिल रहा है, या किसी का क्लाउड है, कोई बहुत पैसे से आ रहा है, या कोई सेलिब्रिटी बन के आ रहा है, उनको ज्यादा पावर मिलेगा। नहीं, हर मेंबर जो उस पार्टी का है उन सब में बराबरी हो, उसको इनर पार्टी डेमोक्रेसी बोलते हैं, और वो सब उस ऊपर वाले पोजिशंस में आ सके इन द राइट मैनर। ठीक है, तो ये कैसे होगा? ठीक है, तो इसमें तो क्या क्या तरीके हैं? रेगुलर इलेक्शंस, बिल्कुल रेगुलर इलेक्शंस होने चाहिए, सो दिस इज अ रिक्वायरमेंट। ट्रांसपेरेंट फाइनेंशियल अकाउंटिंग बिल्कुल होनी चाहिए। अगर ट्रांसपेरेंसी नहीं है फाइनेंशियल अकाउंटिंग में तो कहाँ से पैसे आ रहे हैं किसी को नहीं पता। जिसके थ्रू पैसे आ रहे हैं वो लोगों को इन्फ्लुएंस कर सकता है उसके फेवर में, इवन इफ इलेक्शंस हो रहे हैं। मान लो अगर मेरे थ्रू ज्यादा पैसे आ रहे हैं, फंडिंग आ रही है और वो ट्रांसपेरेंट नहीं है, सबको नहीं पता है, तो मैं सबको ही मेरे लिए वोट कर देंगे, लोगों को पता भी नहीं होगा किस कारण से। और अगर सब कोई देख सकते हैं कि मेरे पैसे आए हैं, so I will be, I'll be seen in that light. Okay, people will not be able to vote for me that easily. Proportional representation of women, बिल्कुल women और minorities को आपको देना चाहिए जगह, तभी तो डेमोक्रेसी बढ़ेगी। मैंडेटरी रोटेशन ऑफ पार्टी लीडरशिप एवरी 5 years, ये मैंडेटरी रोटेशन इज नॉट अ मेन रिक्वायरमेंट। ठीक है, तो आंसर विल बी डी। Let's move to the question number 24, very important. National Commission to review the वर्किंग ऑफ द कॉन्स्टिट्यूशन बनाया गया था कब? 2000 में। ठीक है, मिनिस्ट्री ऑफ लॉ एंड जस्टिस वगैरह ने बनाया था ये देखने के लिए कि कॉन्स्टिट्यूशन जो 50 साल पहले बना है उसको अंडर एक सुप्रीम कोर्ट के जज, चीफ जस्टिस ऑफ इंडिया के अंडर बनाया गया था, ये देखने के लिए कि ये जो बना है ये अभी कंटेम्प्रेरी मॉडर्न इंडिया के लिए सही है कि नहीं, इसलिए इसको बनाया गया था। ठीक है, तो कमीशन रिकमेंडेड दैट प्रेसिडेंट शुड हैव अ फिक्स्ड टेन्योर एंड शुड नॉट बी रिमूवेबल एक्सेप्ट थ्रू इम्पीचमेंट। प्रेसिडेंट ऑलरेडी हैड अ फिक्स्ड टेन्योर, ठीक है, हमेशा से कॉन्स्टिट्यूशन ऑफ इंडिया ने शुरू से दिया है, तो ये न्यू रिकमेंडेशन नहीं हो सकता, इट हैज ऑलरेडी बीन देयर। ओके, कमीशन सजेस्टेड द क्रिएशन ऑफ सेपरेट कॉन्स्टिट्यूशन बेंचेस इन हाई कोर्ट्स फॉर कॉन्स्टिट्यूशनल मैटर्स। ये दोनों ही सही रिकमेंडेशन नहीं है, ऐसा कुछ रिकमेंड नेशनल कमीशन टू रिव्यू द वर्किंग ऑफ कॉन्स्टिट्यूशन ने नहीं दिया था, एनसीआरडब्ल्यूसी ने ऐसा कुछ भी नहीं दिया था, एंड दैट्स व्हाई आंसर विल बी डी। लास्ट टॉपिक, लास्ट क्वेश्चन ऑफ द डे, नेशनल कमीशन टू रिव्यू द वर्किंग ऑफ कॉन्स्टिट्यूशन किसने हेड किया था? तो आंसर है जस्टिस एम.एन. वेंकटचलैया, वेरी फेमस, वेरी वेल रिस्पेक्टेड सुप्रीम कोर्ट ऑफ इंडिया के चीफ जस्टिस, सुप्रीम कोर्ट के चीफ जस्टिस ऑफ इंडिया थे और उनके चेयरमैनशिप में ये बना था। ठीक है, बहुत सारी चीजें उन्होंने बताई थी, बल्कि उनके एक रिकमेंडेशन में ये भी था कि नेशनल जुडिशियल अपॉइंटमेंट कमीशन बनना चाहिए, पर अल्टीमेटली सुप्रीम कोर्ट या जुडिशरी ने उसको हटा दिया। ऐसे कुछ कुछ और भी चीजें थी, उन्होंने बातें की, बहुत सारी चीजों के बारे में रिकमेंडेशन किया ना, दैट विल डिस्कस इन द लेटर क्लासेस। अभी हम कल से हमारा ज्योग्राफी शुरू हो रहा है। ओके, तो एनी पीपल हु आर इंटरेस्टेड इन फिनिशिंग ज्योग्राफी थ्रू एमसीक्यूज, अगर उनके क्वेश्चन ज्यादा गलत होते, ट्रस्ट में ज्योग्राफी में हम उस चीज में क्लैरिटी ला सकते हैं। ठीक है, तो आज के लिए 25 क्वेश्चंस डिस्कशन इज डन and questions were nice and easy but still prone to mistakes, गलतियां उसमें हो सकती है, इसलिए हम उसमें सोचना प्लस नॉलेज दोनों आपको सिखा रहे हैं। ज्योग्राफी का डिस्कशन कल है, शेड्यूल आप डाउनलोड कर सकते हैं हमारे कोई हमारे इस सीरीज के किसी भी वीडियो में, अगर आप डिस्क्रिप्शन में जाएंगे, कमेंट में जाएंगे, शेड्यूल डाउनलोड कर सकते हैं। कल का टॉपिक भी मैं आपको एग्जैक्टली बता देती हूँ ज्योग्राफी में क्या है, एक सेकेंड रुकिए। ज्योग्राफी का कल का टॉपिक है फर्स्ट फ्यू चैप्टर्स ऑफ फंडामेंटल्स ऑफ फिजिकल ज्योग्राफी, जो सबसे इंपॉर्टेंट बुक है ज्योग्राफी की, 11th की एनसीईआरटी फंडामेंटल्स ऑफ फिजिकल ज्योग्राफी, उसके कुछ इंपॉर्टेंट चैप्टर्स हैं। जीसी लॉन्ग के कुछ इंपॉर्टेंट जीसी लॉन्ग के कुछ इंपॉर्टेंट चैप्टर्स जैसे अर्थ एंड यूनिवर्स, जियोमॉर्फोलॉजी, द अर्थ क्रस्ट जिसमें प्लेट टेक्टोनिक्स वगैरह आता है, वोल्केनिज्म एंड अर्थक्वेक्स, वेदरिंग, मास मूवमेंट्स एंड ग्राउंड वाटर, ये टॉपिक्स है कल के लिए। शेड्यूल डाउनलोड कर लीजिए, कल इस पे हम क्वेश्चन डिस्कस करेंगे, जिससे आपका एनसीईआरटी भी कवर होता रहेगा। जो बच्चे सोच रहे होंगे कि मतलब कुछ एनसीईआरटी रिलेटेड क्वेश्चंस हो जाए, so that we'll discuss it here. Okay, bye for today. Today was day 11. Tomorrow will be day 12 of our discussion. See you tomorrow at